I'm here just to share some of the random thoughts about Sir Syed's juristic and legal thought. I'm very much thankful to Professor Shafiq that in the last part of his delivery and speech, he referred to some of the very important statutes and enactment regarding in the broader context of journalism and the aesthetic of writing which Sir Syed favored for the common man. Ladies and gentlemen, the purpose of the law is to lead from anarchy to utopia. In a very popular context, we can say. Now it's a debatable question whether law has been failing or law has been very successful in heralding or embarking on utopia, or just it gets down somewhere in the between. As Sir Syed, as we say that मैं जुल्मते शब में लेके निकलूंगा अपने दरमानदा कारवां को, and then Sir Syed realized that the kind of ta'attul and the inertia which the community has, and how law can become an important metaphor for eradicating the backwardness of the community. The Sir Syed ideas germinated from the Banaras Commission report, which is a very pithy commission report, or education commission report it is called, and the very panoply of the educational reform which Sir Syed have gone through and meticulously studied, and the education commission report, I think how Sir Syed was so beyond time that even in modern India, during 60s we have the education commission, and it was Sir Syed's education commission or Banaras committee, education committee report. So we can see a kind of a continuance of the educational policy of the Sir Syed in the colonial era and as well as in the post-colonial era. When Sir Syed thought of establishing an institution here, Sir Syed was so legally compliant, meaning thereby that when Mohammedan Anglo-Oriental College was going to be established, then it was thought that unless we have a law known as Society Registration Act 1860, Sir Syed never started any kind of the institution. And if you look at as the chronicler suggests, that when 1860 a law was put in place which guarantees Society Registration Act, and I think that it is in the lingua franca, even the layman also understand what Society Registration Act. But nobody realized that Sir Syed never went a step further unless he had that law. And when he had this law, a fear was lurking in the mind of the Sir Syed as an administrator that when it comes to money or some monetary aspect, then that Society Registration Act has undergone to an amendment in 1872. And that amendment is important because that is known as a fund committee. And then after the amendment in the Society Registration Act 1872, it was made possible for the Sir Syed to create Qazi the fund committee, and he created a corpus for the very edifice and architecture of the Mohammedan Anglo-Oriental College. Then we see that Sir Syed educational reform. Sir Syed happens to be judge for almost 37 years. And if you look at his experiences as a Shishtadar in Darul Qaza, as a Munsif, and it is claimed that he also authored a book on law, and he radiated his thought about law and the jurisprudence. Nonetheless, when we see Sir Syed's major contribution as a jurist or as a lawman, having his vivid experiences, then that is the era of 1878 to 1883, where he was nominated to Imperial Legislature. And this was a period where Sir Syed carried the slew of reform, legislative reform especially, and one of the legislative reform happens to be to preserve the culture and the heritage of the Muslims in India. And one of the institutions was known as the Qazi's Darul Qaza or Darul Ifta. In that way, Sir Syed has played a very pivotal role in saying that the Qazi Act 1880 should go through and it should be institutionalized in the administration of justice. So he revitalized the institution of Qazi to deal with the cases of family, the cases of inheritance, and all personal law cases, and he raised the office of the Qazi to an official status. The third reform which the Sir Syed pursued was the law relating to the wakf and the Wakf Act, and then he was of the view that the Roman institution of the trust is based on different ideological foundation, and the requirement of the wakf in the Islam, that wakf, waqif or tawliyat or matawalli, where the ownership of the land rests with the God, is something to be diametrically opposed to the jurisprudence which is known to the Englishman about the law of trust. So he created the Wakf Act. He has been very successful in consolidating the entire Wakf law in this country. And then Sir Syed has a very deep insight to some of the legal writings of the time, and it's very difficult for a gathering like this to just burden you on those jurisprudential books and treatises. But let me note, because this kind of literacy is not only lacking among general person, even the law person and who specializes in Muslim law and family law. So Zakiratul Fatawa, Khazanatul Muftan, Mehrul Faiq, Bahre Rair, Fatihul Qadir, Fatwa Qazi Khan, Sirajiya wa Ashrafiya, Fatwa Alamgiri, Ruddul Mukhtar, are these legal treatises. So Syed was having a very first-hand knowledge about all legal treatises and tried to consolidate these masadir or maraji as sources into culminating the legislative reform in the colonial India. And thereby, it's not surprising that there are 4 cases on Wakf law, and all those cases which have been decided by the Privy Council, Sir Syed has offered his insight, just and fair comment, and have rightly dissented some of the opinions of the British judges in promulgating the Wakf law and precedent, which carries a high evidentiary value in the future case. One of the noted writer, Asif Ali Faizi, who wrote on modern law and the jurisprudence, has been very pithily remarked about Sir Syed that the opinion which he rendered was far ahead than that of the British judges, who have a very myopic perception of the trust and the Wakf. Then in 1882, he has been successful in giving effect to the Indian Trust Act, because some of the societies which were registered in the British India were feeling very uncomfortable with the kind of regulatory labyrinth and the mechanism. Thereby, it was thought necessary that moving from Society Registration Act law to the trust law, where the wishes of the trustee can be given a more clear direction in pursuing the legal education or the education per se in India. Then there was a law known as Indian Contract Act 1872, and which is a basic law even today, and that law stands at the equidistance of the criminal law and the civil law. And the beauty of this law is still today is that it is equally applicable to all family matters. So Syed's vision and juristic articulation, I think that it is something beyond imagination, in the sense that the Indian Contract Act 1872 have never foresaw that immovable property should also be brought within the purview of the Indian Contract Act. So he has been very categorical in demanding that Indian Contract Act, which applies to movable property, should equally be applied to immovable property, so that everything can be brought within the framework of an acceptance and verified the contract of utmost good faith. Then Sir Syed's constitutional and the federal vision is something very praiseworthy, in the sense that he was always talking about the grassroots democracy. And if you look at that the Government of India Act 1935, which is said to be a precursor of the Constitution of India 1950, look, Article 1, the India, that is Bharat, shall be the union of the state. And as a law teacher and a law student, we say that the Indian federalism is centripetal in tendency, it's not centrifugal in character. Or take Ambedkar, what he says, that Indian federalism is unitary in emergency and federal in normalcy. So the Indian federalism is not like the Australian and the American federalism. But if you look at the self-government bill, which Sir Syed was very meticulously and painstakingly marshalling his argument about to get a reality, we find that his federal notions and his federal thoughts about the India is far ahead than that of modern constitutionalists. I'll just refer obliquely to the Ilbert Bill, which Professor Shafik Ridwai Sahib has very vividly reflected upon. But I will just mention that this was a bill. You see that what Shafik Sahib has very rightly pointed out, that he was sometimes supporting Britishers and opposing Britishers. So how can you oppose a Britisher? You can only oppose through the language of sophistication and honey and law and the rights. So that's a serious, I think, adopted that how we can oppose. Because when we are reading about Ain Akbari on history and historians of India, Khalil Ahmed Nizami's book in my student days, and Madam will bear me out, that in fact, sometime Abul Fazl was praising Akbar, and indirectly he was criticizing Akbar. And he was criticizing Akbar in the sense that had he went to that battle and then there would be a lot of devastation. So the language of the biography or the language we require in law to register our dissent, disagreement, it should be very sugar-coated. It should be a word of honey, and then we can beg to differ. So that contradiction which Professor Shafik Ridwai Sahib has pointed out, I agree. And I agree in the sense that what he just mentioned about the Albert Bill, it was a question of equality. Like we read that Rousseau, that equality, liberty and fraternity. People heard these words even much before than that of Rousseau. But when Rousseau talked about, he was talking of the third chamber. In a similar fashion, Ilbert bill was that Indian judge can try the cases of English convicts. So it was the rule of law that is supreme, and that supremacy of the law is the hallmark. Rule of law and the supremacy of law. And the whole architecture of the court was that the cases of the Britishers can be heard only by the British judge. So by the vehicle of the Ilbert Bill, he wanted to create a supremacy of law and the rule of law where the Indian judges are competent enough to hear the disputes of British fellows. Then in 1876, the High Court especially demanded to Sir Syed that we require a battery of lawyers, pleaders and muhtars. And that later was received by the High Court of Judicature of Allahabad, that we should inculcate and promote legal education. And thereby the Sir Syed Law College or MO College or Legal University later on have a provision of the legal education right from the beginning. Although that it has been castigated by Akbar Allahabadi that क्या कहूँ इसको मैं बदबख्ती नेशन के सिवा इसको आता नहीं अब कुछ इंतशा के सिवा. He thought that it is just an imitation, and he also said that कचहरियों में है कोशिश ग्रेजुएटों की, सड़क पे मांग है पुलियों की और मेटों की, नहीं है कद्र तो बस इल्म दी व तकवा की, खराबी है तो फ़कत शेख जी की बातों की. So though he criticized that how legal education is on the anvil and a legal is taking a very leading position in creating a legal literacy in the northwest frontiers, nonetheless the Sir Syed's established institution have not only seen that he has a jurisprudential thoughts, and he has been one of the active members of the Imperial Council or Legislative Council, and not only that, he has been credited to the slew of reforms of the Society Registration Act or Trust Act or the wakf or Ilbert Bill, or lastly the Epidemic Disease Act of 1897, which was claimed during the lockdown in COVID-19. It also owes to the efforts of the Sir Syed, because he has emphasized on public health, and you will be surprised to know that the public health, there is no national law even till date. A state have public health legislation, but at the national level we don't have a public health law per se. And even in the COVID-19 scenario, the government have taken resort to 1897 Epidemic Diseases Act, and then at the best it invoked National Disaster Management Act 2005 without having any kind of a relief and compensation provision which has been engrafted in the Disaster Management Act. So the sledgehammer manner of imposing the lockdown in this country have been a lost opportunity to create a public health law. So Syed was of the view that the public health is very important, and I was told by many people that the 5 places which Syed has chosen to establish this institution, Aligarh was said to be very environment friendly place, and that's why ultimately, although we criticize the weather of the Aligarh and the vagaries of the weather, but you take that Aligarh still happens to be a place that is in comparison, in contrast to the 4 other places we thought to be an environment friendly place. So Sir Syed, despite all his juristic contribution, have also seen that that he was not only preaching but he practiced the legal education in this institution, and he created a Anjumanul Farz duty association and Khadimul Farz, the servants of the duty, Akhwanul Safa. These are some of the institutions which he tried to build in the institution. That speaks that not only we should speak from the metaphors of the rights, we should also transcend from the rights and to inculcate and imbibe the duties also, the fundamental rights and the fundamental duties, which of late the Constitution in 1976 have given 10 duty, now there are 11 duties. So he has a very harmonious perspective of the rights and duties, and in the institution itself, the committees which he constituted bears a living testimony to the fact that the Syed's legal and juristic thought is one of the important area, and that we should also focus in contemporary time. And we also look forward that if the message of Syed of justice should be dispensed, and because in an era where there is a travesty of justice, the need of law and justice becomes all the more important. Thank you very much for giving me very patient. Thank you very much.